Thank you, Mr President. I rise to discuss the necessity to simplify and streamline the Statute Law Amendment Bill of 2022 and the perils in blocking incoherent and outdated pieces of legislation. The minor amendments proposed to the Statute Law Amendment Bill are designed to achieve clarity, relevance and accuracy by correcting references to those other pieces of legislation, statutory bodies and the other authorities, and fixing errors to ensure the law is accessible and the statutes are clear and accurate for our community. I can say with certainty that Victorians would expect to have a confidence in our laws, that they are clear and remain current. The amendments proposed are good housekeeping. I want to outline a variety of important updates being made today. The Competition Policy Reform Victoria Act 1995 needs to be updated to refer to the Competition and Consumer Act 2010 in various paragraphs. These minor amendments reflect the renaming of the Trade Practices Act 1974 Commonwealth to the Competition and Consumer Act 2010 Commonwealth, which was effective from the 1st of January 2011. This Act was not only renamed, but it also introduced more schedules. We must account for this, substituting Trade Practices Act with the Competition and Consumer Act 2010. In Clause 6 will clarify the role of the Commonwealth Minister referred to in this Section 8 of the Competition Policy Reform, Victorian Act 1995, to be the Commonwealth Minister administering Part 4 of the Competition and Consumer Act 2010. They are necessary and important so that the statute stays up to date, consistent, clear and maintained in a regular and orderly manner. Minor corrections are needed to the Aboriginal Heritage Act 2006, Section 65(2)(d) and 2E, points to an incorrect cross-reference to Section 65(1). The cross-reference needs to relate to the time to which the Secretary needs to decide on whether to approve a cultural heritage plan. Section 65(1) is referring to the criteria for the application and the time specified in Section 65(2)(d) and 2E is wrong and should be referred to as 65(2), which stipulates the time frame to make a decision. It is important that there are no errors to ensure that the meaning of the Act can be easily read and understood. In relation to the Domestic Animals Act 1994, this needs to be amended to clarify that a person or body referred to in Section 85M1 relates to the recovery of a dog or a cat is someone who has an agreement with the Council under Section 84Y. This will make the law clear so that there is a clear set of rules that outlines who has the power to recover a dog or a cat, and ultimately this person has the power to seize and dispose the dog or the cat. It's a serious matter. Also included in the bill is amendments to the Housing Act of 1983. This needs to be corrected to be up to date, reflecting the government body directing from the Director to Homes Victoria, making the statute accurate with the change in the name. Other corrections also include errors made in Section 37D to the issuing of notices, declarations and certificates. The statute should refer to the correct person, being the Chief Executive Officer of Homes Victoria. Again, the law needs to be clear on who has the power to issue these notices, declarations and certificates, as the statutes will affect thousands of Victorians and the people in charge should be correctly identified in the statute. The Sex Offenders Registration of 2004 has a typographical error caused by the Firearms and Other Amendments Act 2021. The Justice Legislation Amendment, Police and Other Matters Act 2022 removed the relevant reference, and consequently the amendment which Parliament intend to make has not occurred, causing the statute books to be unclear. The commencement date of the Firearms and Other Amendments Act 2021 and Justice Amendments Police and Other Matters Act 2022 caused the typographical error. The amendment will mean that there is new Class 2 offence, and if sentenced, this person is automatically registered as a sex offender and will need to comply with the requirements of the Sex Offenders Registration Act 2004. This Act assists Victoria Police to keep check on registered offenders by requiring them to report to Victoria Police. This Class 2 offence involves a person using a carriage of service, phone or internet, to prepare them and cause harm and engage or procure in sexual activity with a person under 16. As the law currently stands, simply planning or preparing to cause harm to a person under 16 years of age with the use of a carriage of service is not an offence under the Act, because there is not an engagement of sexual activity, and consequently will not attract a Class 2 offence, requiring the perpetrator to be placed on the sex offenders register. Surely Victorians would expect perpetrators to be stopped in their tracks prior to a crime being committed. This was Parliament's intention. This is an important piece of statute relating to children under 16 who are vulnerable and need to be protected. Yet the statute does not do this because of a typographical error. I would like to draw to the legal case of the Queen versus Darwood 2020, New South Wales DC 841, where the offender, who was in breach of section 47425C, was arrested and released on bail and then re-arrested for a breach of bail engaging in further communication with the victims and further images of themselves being sent. This demonstrates the importance of placing a person who has caused the carriage of service to prepare and plan to cause harm or to engage in sexual activity with a person under 16 on the sex offenders register and to be a Class 2 offence. This stuff is common sense. These reforms are necessary. Everyday Victorians expect strong, functioning laws and the people with the power and the responsibilities to be correctly identified. We deal with these matters in everyday life. I know a bit about rules as a former union secretary. We often took rules out to deal with ambiguity. This is particularly vital during enterprise bargaining agreement negotiations. With employment matters, that stipulations of law and provisions are vital. There could be a dispute around rostering or hours of work or meal breaks or systems of work or processes. If you don't update them and keep them up to date with the modern, changing work environment, you'll find yourself quickly caught out as a union secretary falling short of the standard. You'll find yourself falling short of that time. I know that clear provisions make it easier to interpret and implement. Poor legislation lends itself to be interpreted poorly and leads to time being lost and wasted, and often in the case of an enterprise agreement, go to a tribunal or have the matter determined. This leads to pointless court trials and VCAT hearings. A few years back, the Fair Work Commission went through an important exercise to simplify awards and take out anomalies to make them more readable. This practice is common and widespread. It's about democratising the law. It's about ensuring that it makes sense. It's about the law being relevant to the time and to the way it's being interpreted. So how embarrassing is it the other way? I imagine only in this building is currently building a home, or someone here knows that someone is doing that. Let's think about this. If all the specifications aren't documented and the nitty-gritties aren't documented, it leads to cost blowouts, and most people building homes aren't experts in law. It should require a fancy lawyer to understand it. I don't expect this law to be controversial. I don't expect this law to be scary. I know this law is about common sense. But this amendment allows me to have the chance to talk about the importance of doing the little things. The purpose of the proposed bill is simple. First, we need to correct inadvertent technical errors. Second, there are minor updates to clauses which I've outlined. And thirdly, and I think importantly here, it goes to the heart of what we are trying to do, to make effective laws, and this clarifies that's our intention. From my understanding, Parliament regularly considers and passes statute law amendment bills to correct ambiguities, minor omissions and errors found in the statutes. This bill touches on a variety of different portfolios. There is Treaty and First Peoples, led by the Minister in the other place, Gabrielle Williams. Then there is the Agriculture, led by my colleague in this chamber, Minister Gail Tierney. And then there is the Minister in the other place, Colin Brooks, who deals with a portfolio deeply important to my community, that of housing. And my friend in the other place, Anthony Carbines, who deals with police, and the Attorney-General, Jacqueline Symes, and the Treasurer in the other place, Tim Pallas. Their portfolios are touched by this. For such a straightforward bill, it covers a lot of areas, but I'd like to talk about the importance of the area close to my heart, housing. These changes to the Housing Act are administrative in nature. In 2022, amendments to the Housing Act 1983, quite an old bill, supported by the evolution of the Director of housing with the formal establishment of Victorian Homes and its CEO. Why is this important? You see, the modern day era requires a modern day approach to housing. We recognise that we must modernise the approach of the Commission block and work with local communities to grow our supply of local and affordable housing. Nowhere in this more important than in the electorate of the Southern Metropolitan region. There are old Commission housing blocks in Albert Park, on the corner of Reed Street and Victoria Avenue, and in South Melbourne there are Park Towers and Emerald Hill Court. And close to where I worked for decades, an area I know well is Evans Street in Port Melbourne, which houses two buildings. And from the old to the new, my electorate office is just a hop, skip it away around from the corner to the buildings on King Street. And on the corner of Little Chapel Street, there are two buildings nestled away in a vibrant area. And don't forget on Malvern Road in South Yarra and Union Street and Raleigh Street in Windsor. My community knows firsthand the importance of public housing. That's why I'm proud that we have committed $5.3 billion to the Big Build housing build, which is the biggest single investment in social housing of all states and territories. But who can be surprised? Victoria leads the nation. It's also our biggest investment as a state into housing. It'll deliver more than 12,000 homes, including 2,400 affordable homes in Victoria who needs them the most. It'll boost our social housing supply by 10%, a big deal for thousands of Victorians who need them most. But it won't just benefit my community, the flow-on will help regions with 25% of funding allocated to regional Victoria. And hardly a surprise for a program of our government, the housing bill will create an average of 10,000 new jobs each year, creating new employment opportunities for all Victorians. So the bill is straightforward. The purpose of the bill is clear. The bill revised the Statute Law of Victoria to amend grammatical, typographical and other areas in legislation. On the topic of housing, the amendments outlined have no substantive effect on the Housing Act. Rather, it corrects errors that are relevant to the provisions. It's all about ensuring that Victorian statutes remain relevant and accessible to the Victorian community. Our community deserves to have confidence in the clarity and accuracy of the legislation that affects them. So I'm pleased that the Department and the Premier of Cabinet work so closely with a variety of government departments touched by this bill. It's how government is supposed to work. Why are there so many errors? Well, whenever we draft legislation, I know from our side we approach it with sanctity, with the utmost care and to the highest professional standards. But occasionally, all sides of politics, including those opposite in the coalition, make minor errors, may forget to include or accidentally include irrelevant details in legislation. Put simply, mistakes happen. We are a government of action, and we are a government that aims to quickly identify any errors and to rectify them as soon as possible. This ensures that our legislation is world standard. But don't forget the Charter of Human Rights. Responsibilities Act 2006 came into place 23 years after the previously mentioned Housing Act of 1983 came into place. Back then, there was no Section 28 dealing with the compatibility rights, and now there is. Times have changed and we must change with them. So in conclusion, Mr Speaker, these sorts of bills are passed on a regular basis by the House. It's about ensuring we keep modern, efficient and accurate. And it's about, and it'll help ease the administration of our laws. This bill lapsed at the end of the last Parliament, and to date there has been no statute law revision bill in a few years now. And I think everyone in this room knows we can imagine why. With a once-in-a-generation pandemic, there have been other demands and priorities on our government. But now we can keep up with some good housekeeping, and that's why I commend the bill to the House. Thank you.
Ms. Makora.